Hello, I'm Professor Michael Hart at the College of Southern Nevada, and this is my presentation for Constitution Day 2026. And the case is Pond versus Isabella County, decided by the High Court on June 23rd, 2026. It follows on the heels of Tyler versus Hennepin and is another principled Supreme Court decision pertaining to property rights. I say principled because in recent decades, we saw that many Supreme Court cases pertaining to property rights were driven not so much by principle as by specific set of facts in each case. So was the case in the 1980s, 90s, and early 2000s. But we see that with Tyler versus Hennepin and with Pond versus Isabella County, we get a resolution of certain principles, and a very decisive resolution. Both of those cases decided by the Supreme Court unanimously. And if the Tyler case, which I also reviewed for Constitution Day 3 years ago, if that case was decided in favor of private property rights, then the Pond case was decided in favor of state interest. So, what happened in Pond versus Isabella County? The Pond estate, according to the assessor of Isabella County, Patricia DePriest, failed to pay a tax of $2,242. The dispute was because the Pond family claimed they did not really owe this tax because they were entitled to an exemption, primary residence exemption, which in case of Isabella County exempted homeowners from partly from local property taxes. But when the case reached the Supreme Court, it arrived in the posture that said the tax itself for the year 2012 is valid and the Pond family is responsible for this tax. But what happened to the property itself? Well, it was seized by the county and sold at an auction. And the auction price for which it was sold was roughly $76,000. Whereby the assessed fair market value was roughly $194,000. And the real dispute between the Supreme Court was, what is the homeowner entitled to? Is the homeowner entitled to the difference between the fair market value minus the tax that he owed, or is he entitled only to the actual auction sales price minus the tax that he owed? And unanimously, the Supreme Court answered he's only entitled to the actual sales price at an auction minus the tax that he owed. Like I said, the decision was unanimous. The opinion of the court was almost unanimous. There were two concurring opinions, and the concurrent opinion by Justice Sotomayor, which was very short, and one page long, basically stipulated that the court in this case did not determine what constituted a fair auction. She just wanted to emphasize this point, but she joined fully the majority opinion written by Justice Alito. Justice Thomas, for his part, was the only justice who did not fully join the majority opinion written by Alito, and he wrote his own opinion, which in parts read like a dissent and was certainly in tone and in substance a bit more sympathetic to the Pond family. But again, the decision itself was unanimous. So what did the court decide? Again, the crux of the matter is the Constitution does not automatically require payment of a property's hypothetical fair market value whenever a government conducts a tax foreclosure sale. So the auction price can serve, in fact, as the constitutional baseline, with the former owner receiving the sale proceeds that remain after the tax debt and lawful expenses were satisfied. And the rule applies only when the foreclosure and auction were fairly conducted in a manner consistent with the historical tradition of tax sales. This point is important because this is the point that explains why the case was remanded back to the Sixth Circuit Court of Appeals in order to decide whether, in fact, the manner of the auction was consistent with historical tradition of tax sales. And so the Pan family lost this case and received only $76,000 minus $2,242 of the tax that they owed. Now, initially, as the facts of this case were developing, the Pan family did not receive anything at all. And the reason why initially they did not receive anything at all and had to sue for their money was because when their property was liquidated, it was still before the Supreme Court decided Tyler versus Hennepin. And remember, Tyler versus Hennepin stands for the proposition that a state may not deprive the homeowner of a surplus value and must return the surplus value to the homeowner. So the Pan family did have to sue. They did get some of the money back, but of course they wanted to have the surplus back based on the fair market value. Justice Alito's opinion, in my view, is driven not only by his reliance on history and tradition, but also on anxiety, a very practical one, of what would happen if Pan were to prevail. And in fact, Alito addresses this explicitly. And a lot of municipal governments filed friend of the court briefs. And in their briefs, they stated that, look, if you allow Pan to prevail, then what's going to happen to us as governments going forward? We rely on these sales in order to get delinquent tax revenue. And without it, we cannot function as governments. And if now we are told that we have to return the entire market value, fair market value, this will be such a severe blow to our finances, we won't be able to function for very long. So there's a very practical governmental administrative matter at stake in this case. And I dare to say this is the main reason why the case was decided the way that it was decided. Now, Justice Thomas, in his substantive concurrent opinion, said that authorities generally had to pursue personal property before taking land. Okay, so if they want to satisfy some debt, according to Justice Thomas, the tradition says, history and tradition say, well, you have to go after personal property before you take land. The second point that he made is if you do take land, then you only have to take as much of it as necessary to satisfy the debt. Well, I wonder how this would work in the 21st century when it pertains to single-family homes. So if it's a house, would you only take one bedroom and sell that? Or if it's a condo, would you what would you do? How would you separate one or two bedrooms from the rest of the condo? So that doesn't seem very practical, but nevertheless, this is one of the points raised. And authorities had to observe rigorous notice and procedural requirements. So it now remains to the Sixth Circuit Court to figure out whether these requirements were in fact followed. And auction procedures were supposed to produce a price that closely resembles fair market value. And arguably, they never did, at least not in recent decades. And one of the reasons why is because auctions are a tricky thing. They typically require payment in cash and without seeing what's really inside the house, without a full inspection. So the buyer takes a lot of risk. Now, who has the money to pay for the house in full, and who has the ability to take such a significant risk as to buy a house almost sight unseen? It could be gutted inside. And the answer to it is well-financed organizations. And what they have learned is that if they don't bid against each other, they can get these houses for pennies on the dollar. And therefore, it's kind of an insider's game. So the auction prices, because of this, have been driven down artificially. So that's the point that Justice Thomas, I think, addresses. So when these limits are violated, then there's a problem. So his narrative, Thomas's narrative, is a lot more sympathetic to Pan, but nevertheless, the decision itself is a unanimous decision. So the bottom line is on the Fifth Amendment, Pan loses, but Pan also loses on the Eighth Amendment, the excessive fines clause, because the Supreme Court said, look, this is not a fine because this is just administrative procedure. The point is not to punish the homeowner. The point is to recover delinquent taxes. And when that happens, there's no Eighth Amendment protection. So it's just an all-around disaster for Pan, and a big loss for property owners. So how is this different from the Tyler case 3 years earlier? Well, the Tyler case did not raise the question of fairness of the price at which Geraldine Tyler's condominium was eventually sold. It was sold for $40,000. Tyler didn't say, well, it should have been sold for more money. So that point was not contested. The only thing that was contested in that case was the fact that she didn't get any surplus back. She should have gotten $25,000 after the county satisfied $15,000 debt due to taxes and late fees. But the county wanted to keep all of it. So Geraldine Tyler successfully sued for the surplus back and was awarded that by the Supreme Court. But you see, in this case, it's the fairness of the sale price itself that was at stake, and Pan family lost. So this is a big loss for property rights. Thank you very much. I hope you enjoyed the presentation.